The involvement of politicians in the appointment will no doubt ultimately lead to interfering by these individuals in the judicial process. Such interference will wrongly justified as a payment of favor. Persons selected for judicial office shall be individuals of integrity and ability with appropriate training or qualifications in law. Any method of judicial selection should safeguard against judicial appointments for improper motives. The chief judge should not be solely responsible for preparing the shortlist. The general perception is that the appointment of judicial officer is influenced by politics. The mode of appointment should be such that more parties, especially independent parties, should be involved. The mode of appointment of judicial officers is therefore general principle. In the communique issued at the end of the General Conference of Port Harcourt in 2011, the NBA observed there are a lot of legal practitioners in Nigeria who are not only honorable, patriotic, transparent, hardworking, and incorruptible, but also fit and proper for appointment to the bench and elevation to the behavior, but are bypassed on account of mundane considerations, especially the fact that they should allow those who have labored and suffered on the bench to benefit from such appointments, quote and unquote. After all, it is said that these private legal practitioners have been enjoying themselves. We opine that if it is indeed, it is based on connection as many believe it is, it can only lead to the involvement or interference by non-judicial or legal actors in the process. The involvement of politicians in the appointment will no doubt ultimately lead to interfering by these individuals in the judicial process. Such interference will wrongly justified as a payment of favor. Persons selected for judicial office shall be individuals of integrity and ability with appropriate training or qualifications in law. Any method of judicial selection should safeguard against judicial appointments for improper motives. As we have pointed out repeatedly, the poor quality of appointments in the judiciary will be the bane of that judiciary. We therefore propose as follows. Those who apply for appointments as judicial officers, especially to the High Courts, Federal High Court, NIC, should be subjected to written tests conducted by an independent board. The results of such an examination should be published within 6 hours of the completion of same. Presently, even though there's a written test, the results are never published. And it is never easy to say whether reliance was placed on the outcome of this result for the shortlist. Such an examination should not only test their knowledge of the law, but equally test their verbal and quantitative aptitude. Thus, the test should be structured in a manner that ensures the prospective judicial officers show their legal writing skills, comprehension, and legal reasoning skills. The judicial appointment process should be reformed to focus on skill, professional and technical ability in relation to integrity and personality. Appointments into the bench at whatever level must henceforth be predicated upon merit and concurrent recommendation from the bar. My lords, may we respectfully note that the bail process continues to be a tool of abuse of judicial power, oppression, unjust demands, overcrowding of the detention center, and delay in many courts in Nigeria. This abuse is best highlighted with order made by the Chief Magistrate Court last week, Obin Nanjemanzi, for the remand of the Owerri Correctional Center of our colleague Chineduago after arraignment on charges alleging cyber stalking, criminal defamation, and incitement. Some judges and magistrates are increasingly becoming enablers of political oppression and suppression of dissenting views by remanding persons charged with alleged criminal defamation or cyber stalking under Section 24 of the Cybercrime Prohibition and Prevention Act 2015. Judges and magistrates increasingly deny bail when such charges of internet or online related offenses are preferred against defendants despite the matters being ordinarily bailable. It is then worrisome that even though the law provides that a court may require a suspect or defendant to execute a bond with or without sureties for his appearance before a court, our courts rarely utilize such procedure. Rather, the bail process has been rendered very technical, time-wasting, and cumbersome. Sometimes court impose bail conditions that amount to denial of bail. At other times, they will impose a condition requiring the prosecutorial agency or some other third party to verify sureties before a defendant could be released on bail. This has led to allegations of extortion, abuse, and prolonged detention even after bail has been granted because of the deliberate delay in verifying such sureties. This has also given the impression that justice is not served in such circumstances, but that the judges may have rather chosen to enable the unjust incarceration of citizens to say that which makes for saying that which makes somebody unhappy, uncomfortable. It is well known that the essence of bail is to ensure that the defendant attends court to answer charges that may have been brought against him. It is therefore worrisome why a court will refuse bail to a person charged with an offense that does not carry more than 3 years imprisonment upon conviction. Judges and magistrates who deny bail to defendants in such circumstances must know that judicial should not be seen under any circumstance to side with those who wish to silence criticism, dissent, and refuse to be held accountable. I need not remind us that when the government of Jimobodo charged Chief Atomankwe, a publisher with sedition, for writing a book in 1982 titled How Jimobodo Rules Anambra State, a book that seriously attacked Chief Jimobodo, then governor of old Anambra State, accusing him of corruption and tyranny, the Court of Appeal, in quashing his conviction by the High Court, held that sedition law, that is sections 50 and 51 of the Criminal Code, is inconsistent with section 36 of the 1979 Constitution, now section 38 of the 1999 Constitution, and therefore void, and the conviction of Atomankwe was overturned. In the judgment of my Lord Honorable Justice Olatawara JC, as he then was, in quashing that judgment, the citation is supplied here. It is my view that the law of sedition, which has derogated from freedom of speech, guaranteed under this Constitution, is inconsistent with 19th Constitution. More so when this cannot lead to a public disorder, as under section 4.1 of the 1979 Constitution. We therefore use this opportunity to call on the chief judges of the Federal High Court and the High Courts of the states and of the Federal Capital Territory, Abuja, to exercise powers given to them by section 187 of the ACJA and by the requisite provisions of the ACJL by making regulations for the registration and licensing of corporate bodies or persons to act as bondspersons within the jurisdiction of the court in which they are registered. We must make a commitment to ensure that the whole process is made in such a way that ensure that the defendant appears in court to face trial and same is not abused. We will not fail to use this opportunity to call attention and deprecate the stateful circumstance surrounding the hearing of the appeal filed by a colleague, Bright Ngene, against his conviction by a magistrate court in Enugu State. The prolonged delay in determining the appeal gives an impression of a deliberate effort to ensure that his appeal is never heard. It is disturbing that the matter which initially reached judgment stage was truncated on the very day of judgment because the judge refused to deliver judgment and proceeded to recuse himself. Owing to the public outcry and the long delay in assigning the matter to another judge, the matter was adjourned to another judge, who unfortunately, on the 23rd of September 2025, recused himself yet again. It is beginning to look as if there is a concerted effort to ensure that the appeal is never heard, so that Bright Ngene will serve the full term imposed on him by the court. If this is indeed true, then this is not the face of justice we want to present to the world. We wonder if the judiciary in Enugu State has become weak, unwilling to live up to the judicial oath to do justice to all men without affection of ill will. For how long shall we allow the cumulative effect of the violation of Mr. Ngene's right to a fair hearing and timely hearing of his appeal? This is, to say the least, is a painful reflection of systemic delay that risks decreasing public confidence in our judiciary delivery institutions. It is a convenient point to remind us yet again of Lord Atkins' statement in his certain judgment in Liversidge and Anderson. And I quote, "In England, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which on recent authorities we are now fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified in law." The continued detention without any judge accepting to hear Bright Ngene's appeal strikes at the heart of our collective sense of justice as a profession. Bright Ngene deserves such justice, and the willful refusal of the judges of the Enugu State High Court to hear his case, I repeat, strikes at the heart of justice and portrays it in a bad light. According to an African proverb, if the crocodile eats its own eggs, what then will it do to the flesh of the frog? My lords, I respectfully crave the court's indulgence to address the matters that have weighed heavily on the public conscience of our nation. Some time ago, there was outrage over the arraignment of 75 protesters, including 32 minors, who were charged with serious crimes like treason and incitement to mutiny. Arrested during August end-back government protests, the young defendants, evidently weak, unkempt, and malnourished, were presented in court after nearly 3 months of detention. The case brought to the fore the treatment and application of laws to minors in conflict with the law. It also highlighted the absence of detention facilities or boster homes for detention of minors, as well as highlighted failure to seek alternatives to remand for children or minors in conflict with the law. The case calls to mind the role of the judiciary in ensuring that where the prosecution insists on doing the wrong thing, the court would come to the aid of such ones. Our courts are urged to develop best practices to ensure that children are neither charged along with adults nor sent to adult detention facilities. The courts should also activate the provisions of the law about how to determine the age of children where there is doubt about sin. The issue of digitizing our courts remains pressing. The Supreme Court Rules 2024 provided a foundation for electronic filing, but the system is yet to achieve full operationalization across our superior courts. Our courts still struggle with manual processing that encourage delays and inefficiency. In 2025, this should no longer be acceptable. Many jurisdictions have shown that technology can drastically improve efficiency, transparency, and public trust. Nigeria must not lag behind. The NBA therefore renews its call for adoption of electronic filing and service of processes, digital recording of court proceedings in all superior courts of record, efficient case management system with strict scheduling and time slots, integration of legal mail as exclusive medium for court lawyer communication. No judiciary can command respect if questions persist about the discipline and integrity of its officers. The NJC must be unwavering in upholding ethical standards while at the same time protecting judicial independence from political interference. As a dearly late beloved past Chief Justice of Nigeria, Mohammed Lawal GCON, said, for a judiciary to function effectively, it must have the trust and confidence of the people. This trust must be strengthened only when judges are seen to be above reproach and when the trial processes are swift, fair, and transparent. We must therefore renew our focus on access to justice for indigent citizens, speedy trial of cases, and regular inspection of detention facilities to curb unlawful incarceration. The judiciary is not an ivory tower immune from the gaze of the people. It is an institution that must constantly earn public trust through fairness, timeliness, and transparency. Many magistrates and high courts operate with derisory infrastructure, from poor electricity supply to a lack of recording equipment, making effective case management difficult. The viral video of the leaking roof of a magistrate court in Anambra State highlights the neglect into which the inferior courts have fallen into. We therefore use this opportunity to call on all the persons responsible to make intentional efforts to improve the infrastructure of magistrates and judges of lower courts. To our colleagues, newly conferred with the rank of senior advocates of Nigeria, and members of the INABA, you have my hearty congratulations. Your elevation is a product of excellence and hard work and integrity. The rank is not an ornament, it is a call to higher duty. You are now among the torchbearers of the profession, mentors, leaders, and custodians of justice. Younger lawyers look up to you, not only for technical brilliance, but for ethical guidance. As you don the silk, may you remember always that privilege comes with responsibilities. We urge you to adhere to high standards required of the rules of professional conduct. We will not hesitate to investigate and initiate disciplinary action against any legal practitioner if a prima facie case is made against him or her. We are currently investigating allegations against our colleagues, whom it was found by Judge Ewan Partin of the First Tier Tribunal Property Chamber Land Registration in the United Kingdom to have contrived evidence in order to secure the registration of a property in his favor. We have in particular written a letter requesting explanation, first of all from Chief Mike Ozekome-Sen, and as soon as we get the addresses of the other persons who understand that Nigerian laws, also send similar letters to them, so that they will all have an opportunity to explain. The MB also reiterates its call for a review of the guidelines for conferment of SN rank to broaden inclusivity, particularly for academics and law teachers. We also call for the removal of the guideline that requires that a person facing disciplinary action or a pending criminal case should not apply for the rank until the determination of the case. It is our belief that this negates the constitutional presumption of innocence and indirectly imposes punishment on the person who may otherwise be innocent. Such a person should be able to apply, as the system can always kick in to weed him or her out if there's a finding against them either in a disciplinary process or in a criminal proceeding. Not to be forgotten is the fact that the provision can be abused to ensure that a person does not apply for or even get a rank. We believe that since there is a procedure for withdrawal of the rank among early lessons, the above requirement has become odious and unconstitutional. As we commence the new legal year, let us recall the words of Justice Taslim Elias, that justice is the greatest concern of man on earth. Our collective duty, the bar and the bench alike, is to ensure that justice is not a distant ideal, but a daily reality for all Nigerians. The NBA pledges its continued partnership with the judiciary to pursue reforms, advance digital transformation, enhance access to justice, and strengthen discipline within the profession. May this new year mark a turning point in our collective resolve to restore public confidence in the judiciary and to build a justice system worthy of our democracy. Thank you for your kind